싱가포르와 한국 법원의 실무가들이 최신 법정 기술에 관하여 주제 발표와 토론을 하는 방식으로 진행됩니다. 발표와 토론은 영어로 진행되고 통역이 제공됩니다. 오늘 현장에 참석해 주신 분들께서는 앞에 놓여진 통역기를 이용하실 수 있습니다. 현재 채널은 한국어 통역으로 맞춰져 있습니다. 따라서 별다른 조작 없이 귀에 착용하셔서 들으시면 되겠습니다. 특별 세미나 발표 및 토론의 사회를 맡아주신 권순영 대법원 사법정보화연구회 회장님을 소개해 드리겠습니다. 권순영 회장님께서는 사법연수원을 제22기로 수료하시고 1996년 판사로 임관한 이후 법원 행정처 법정심의관, 대법원 재판연구관, 대구지방법원 김천지원장 등 사법부 요직을 두루 거쳐 현재는 서울고등법원 상사기업법 전담부 재판장으로 근무하고 계십니다. 특별 세미나의 발표자와 토론자분들은 권순영 회장님께서 간략하게 소개해 주시도록 하겠습니다. 그럼 지금부터 권순영 회장님께서 특별 세미나 발표 및 토론의 진행을 맡아 주시겠습니다.
Judge Lee, thank you very much for the kind introduction. Good morning to all our distinguished guests. Thank you so much for attending in person or watching online. Due to the coronavirus pandemic, this morning session will be held as a video conference between Seoul and Singapore. Fortunately, the time difference is only 1 hour. We appreciate your understanding. Before we begin, I would like to express my deepest gratitude to the Judicial Policy Research Institute, the Korean Association of the Law of Civil Procedure, and the Korean Association of Criminal Procedure Law for co-hosting this international symposium. And I truly appreciate the opportunity to act as the moderator of this meaningful symposium. The theme of this morning session is Court Technology and the Latest Developments. This is a highly pertinent topic at this time. It's been about 10 years since electronic litigation was first introduced in our courts, which has led to substantial changes in the judicial process. In addition, the use of video conference hearings based on e-litigation has been activated in 2020 due to the coronavirus pandemic. These changes are driving us to make use of the latest IT technologies and the digital platform in trial proceedings. It will also be very useful for us to refer to the Singapore court, which has an excellent e-litigation system and actively utilizes current IT technologies. In these respects, our symposium should prove to be both timely and informative. The morning session will have 2 speakers and 2 panelists. It is truly a great honor to have such prominent guests. Let me introduce the first speaker, Justice Aedit ABDULLAH. Justice ABDULLAH was appointed Judicial Commissioner in 2014 and High Court Judge in 2017. He obtained a Bachelor of Law from the National University of Singapore in 1994, as well as a Bachelor of Civil Law from the University of Oxford in 1998, and a Master of Public Management from the National University of Singapore in 2007. He joined the Singapore Legal Service in 1995 and was appointed Chief Prosecutor at the Attorney General's Chambers in 2011. In a recent interview, he emphasized the importance of right mindset and preparation in virtual hearings as the chairman of the Singapore Academy of Law Legal Education Cluster. The topic of his presentation today is the development of court technology system in Singapore. Now let me bring Justice ABDULLAH into the conference. Are you connected? Can you hear me well?
Thank you.
Yeah.
Thank you. Good morning.
Everyone, please welcome Justice ABDULLAH with a big round of applause. Justice Abdullah, please take the floor. Thank you.
Thank you so much. Good morning, everyone. I'd like to thank Judge Kwon Sun Hyung, the moderator and president of the Association of Judges for Judicial Informatization, as well as my fellow speakers, Judge Won Ho Shin and Judge Lee Suk Yeon, who will be coming on after me. I'd also like to thank the Korean organizers who have been very kind in assisting the Supreme Court of Singapore in organizing today's event. Before I start, I'd like to apologize. Subject to our rules, we will have to keep our masks on for the duration of the speech this morning. But without further ado, the topic in question is the development of court technology in Singapore, and I hope to do this in a series of different topics, looking at the development historically, the environment that we have to operate in, an overview of our current projects, as well as an outline of what we hope to achieve in terms of future development. Taking first general development, we have a historical development from 1993 to 1997 when we first developed the EFS system. And this took a few years of work, and the objective was to replace paper and to replace paper handling throughout the court system. Now, everyone would know, of course, that paper handling is a very cumbersome process. Historically, we lost a lot of court files, things were delayed, and we incurred a lot of cost in maintaining the paper documents within the court system. So the EFS development wasn't very welcome at the time, but there was, of course, a lot of cultural resistance to it. People were quite used to handling paper all the time, and it took a bit of while before people got comfortable with the electronic filing system. And it served us well for quite a number of years. But in 2013, we embarked on the next iteration of the development with the e-litigation system, or e-lit, as we called it, which was to bring in greater digitalization and greater adoption of electronic processes in our workflows. Then in 2017, we brought it forward through our Courts of the Future roadmap, which I will elaborate on shortly. Along the way, various other systems were also developed, covering criminal, regulatory offenses, and family cases. This created a situation where we had different filing systems for different areas of practice, and it emanated as different projects in different courts. Now, while this may have been exigent and necessary in the circumstances at the time, this created some potential problems for the future, which I will again address very shortly. But turning first to the Courts of the Future roadmap, which was announced by the Chief Justice in 2017. This is basically a technology blueprint, which was the product of extensive consultation and feedback involving various stakeholders, including lawyers, academic, and government agencies. The objective of this exercise was to ensure that the court system took into account the needs and the priorities of all of the users of the system. So, from this extensive exercise, we identified a few areas of focus and development in the various phases of hearings, namely pre-filing, hearing, and post-hearing. This is a brief summary of some of the initiatives that were developed. So you'll see that we divided up in these three phases. And in terms of some specific projects, for example, for pre-filing or pre-hearing matters, we wanted to develop self-help solutions, including developing information access through our judiciary portal and a virtual assistant called Ask Justin. We wanted to develop systems to assist lawyers and litigants, including through the My Cases portfolio and the development of outcome simulators, systems to provide online dispute resolution and e-settlement, and systems to allow for pleading of guilty in some regulatory or minor criminal offenses. And then moving to the hearing phase, we thought that it would be essential to develop e-scheduling, easy video conferencing and streaming, litigation support through what we call a war room, as well as a greater facility for e-trials. Following from that, after the hearing itself, we wanted to be able to utilize the data and information that was generated through the system for better development of judicial and government policies. And we thought it would be opportune to consider whether we could implement decision support for the judges through artificial intelligence. Shortly after the Courts of the Future framework was rolled out, another important initiative for us was the development of centralization within the Singapore judiciary. Now, it might be surprising for all of you in Korea. You are much larger than us, both in terms of size and population. But even in our small city of 5 million or so, we managed to somehow develop different systems at different times in different courts, even though we are only a few hundred meters away from each other. So in 2019, we established the Office of Transformation and Innovation, which is intended to coordinate and integrate all technology, transformation, and innovation efforts throughout all Singapore courts. And my colleague, Mr. Ken Hwee, is the current chief officer of that office. One of the primary objectives of it is, of course, to save time, money, and effort to reduce any duplication of projects and the use of resources. Now, before this, as I mentioned earlier, we had developed different systems or different areas of work. While each of these systems was good in its own way, there was segregation and data couldn't be readily interchanged between them. Work processes were a bit different. And even the lawyers faced some difficulties because the interfaces were different and they had to get used to different ways of putting in their information. So one of our objectives for the midterm is to ensure that we move all these systems together, and that is a prime area of focus for the Office of Transformation and Innovation. What also happened post-2017 and the development of the Courts of the Future framework is that we tried to refine it, taking into account an important area of focus identified by our Chief Justice, which is to ensure continued access to justice. We came to our realization and understanding that in adopting technology, we must not neglect the ability of laypersons, litigants in person, to obtain justice. And the Chief Justice, in his speech, Technology and the Changing Face of Justice in 2019, identified 3 particular gaps, which we bear in mind as we develop our technology focus, and that is to close any physical gap that could occur between the litigant and the courtroom, to close any resource gap, and also to close the literacy gap. So essentially, the Court of the Future still provides a general roadmap, but we have refined it in several ways, which I hope to touch on shortly. Moving on to the environment, just to give an understanding of the situation in Singapore, and I believe it will be comparable to what you have in Korea, we have to bear in mind a number of national initiatives, in particular, the Smart Nation Initiative, which is a nationwide project to ensure that the whole country is able to develop digitally, that technology is rolled out to provide the best experience for all citizens as they navigate the government systems, as they go through their lives, and to make sure that we make the best use of technology for our greater prosperity and development of our society. So a number of initiatives have come up from the Smart Nation project, which is helmed by a minister in the cabinet. Importantly, we also have the Government Technology Agency, which is a very important partner for a lot of government departments and agencies in their efforts to promote technology, to adopt technology. They have a lot of bright stars in their employment who are able to assist us in the course of our technology adoption, and they have a number of projects underway which feed into some of the things that we are trying to do as well. The stakeholder environment in Singapore is also something that perhaps I should explain a little bit more. The judiciary, of course, consists of all the courts in Singapore. An important partner for us in Singapore is the Singapore Academy of Law. Now, this is an organization which is more than an association of lawyers or judges. It is actually a single body that brings judges, lawyers, academics, and law students into a single organization And the closest parallel, I think, would be the Inns of Court in England. The historical role was primarily in terms of networking and building up a fraternal ties, but over the years it has also developed considerably in terms of provision of legal technology. And an important thing to note is that our primary research tool in Singapore, LawNet, is actually owned and run by the Singapore Academy of Law. So that's where we do all our case law and most of our legislation-based research. So they own the LawNet system. The Ministry of Law is, of course, equivalent to the Ministry of Justice in many jurisdictions. I mentioned the Government Technology Agency. Another important organ or entity that we have to liaise with is the Attorney General's Chambers, which houses all the prosecutors and most of the government lawyers, and the Attorney General is also the head of all the other government lawyers as well. The Law Society is the main professional body in Singapore for lawyers, and they have a lot of activities that overlap with the work of the judiciary and the Academy of Law, of course. And we have to bear in mind that increasingly a large number of the public will be interfacing or interacting with the legal system on their own without lawyers for various reasons. Sometimes they don't want to incur legal costs, and sometimes they prefer to handle things on their own. So we have to make sure that our systems accommodate their needs as well. And thus, as we move forward, of course, the primary areas of interest would include the use of artificial intelligence. I think everyone is trying to see when it is possibly deployed well. Data mining is important for us. We want to be able, as I said, to harness data and harvest data, both for our own purposes and to share with other agencies, such as, for example, our family ministry, which will be able to get important data from the family cases that I found. But of course, as we embark on that, we need to make sure that the data privacy is respected. We've also considered, and will always consider, the possible use and appropriate use of blockchain technology where it can provide security and trustworthiness. And importantly, as I mentioned, we need to ensure that our activities, all our initiatives align with national projects and priorities and initiatives. And in particular, we have a national e-payment system, and we're developing a national digital signing and identity system as well, which we need to incorporate into our projects. So moving on to some of our current projects and near-term projects, let me start first with the impact of COVID-19. And in common with everyone else in the world, COVID-19 has, of course, led to the greater adoption of remote hearings. For 10 years or more, we have tried to push for video hearings. The adoption was quite spotty. There was a lot of resistance. A lot of lawyers said, why do we need this? We're just about 5 minutes cut right away from the courts. We don't really need to adopt this. We have managed to push it in some minor areas, including pre-trial conferences, mostly administrative hearings, but generally not for substantive hearings. All this, of course, changed through the onset of COVID and the need for social distancing, and we managed to roll out our remote hearing capability quite rapidly, thankfully. But it has also led to a cultural change. Lawyers now are very comfortable with remote hearings in most situations, and sometimes they actually prefer it. For instance, in trial matters, initially they were reluctant to do it. They claimed that they needed to do physical hearings with the witness in court so they can observe how the witness is reacting to their questions. That is probably a bit overblown and overstated. But in any event, now because of our mask requirements, more lawyers don't want to wear masks while they question, and now they're much more ready to do it from the comfort of their offices where they can take off their masks and just dial in for a remote hearing. So some of the challenges we faced, of course, in developing remote hearings was the implementation of security and the appropriate legislation to support this. And I think we managed, through the work of the Office of Transformation and Innovation, to actually ensure that we have a secure environment. We have some niggling issues about document exchange, which have shown to us the limitations of our current e-litigation system, which we are trying to address in various ways. We have tried to push out as well greater remote use of authentication and attestation in some contexts. And of course, within the court system itself, we've actually embarked on quite a lot of changes in our provisioning of hardware and training of our officers. Let me turn then to some of our current projects. We have a few, and this is just a sampling. What I will highlight this morning in particular would be our SG Courts app or application on mobile systems. We have embarked on a secure signing of documents and also authenticated court orders. What I can explain briefly is that in Singapore and in common with other common law jurisdictions, after a judgment is given, it is really up to the parties to try to enforce their orders. So they will need to extract an order of court, and then they need to show it to the banks or other government agencies to get the court order implemented. Now, of course, the other people who are given these things will need to be reassured that what they're given is authentic and genuine. So historically, people would have had to come to our courts to get it stamped and signed off by a notary, and then go back to the agency, so it will take a lot of time. We had considered adopting blockchain technology to address this problem and to ensure that there is common acceptance of authenticity. But Mr. Tan Ken Hwee and his team realized that we didn't need to adopt blockchains, and it was sufficient for us to use a QR code authentication system, which we have done and which we have implemented at much less cost and technology burden for everyone. We're also examining the use of e-bundle systems for documents. Again, in common with many common law jurisdictions, we have a lot of documents being filed into courts, which are sometimes very difficult to handle. Our e-litigation system is not geared for that, so we are exploring various alternatives. We have the motor accident case outcome simulator, which is a technology-assisted system or framework to enable people involved in motor accident cases to have an indication of the likely outcome and decisions if they were to pursue it in court. And we hope by this to encourage greater settlement, especially in motor accident cases. We may adopt the same methodology in other small value disputes. We're also trying to encourage asynchronous hearings, which is basically hearings which occur at different times. Not everyone has to appear before the judge at the same time. We've been implementing it to some extent in emails, but this is of course quite cumbersome. So we're trying to develop a system which will allow this to be done more seamlessly. So let me take you to the SG Courts app. So the idea is to have everything on your mobile phone or to develop towards that approach. And we see it as a constant iterative process. The app is never finished, like whatever else you have in your mobile phone, such as Uber or other applications. There will always be a new version coming out with more features. So Mr. Tan Ken Hwee describes it as our super app. So currently, and this is from Mr. Tan Ken Hwee's phone, we are able to show the hearing diary, and on the second screen, we are able to show the e-litigation front end with some of the e-litigation documents from a specific file, and that's on the third screen. So the idea is that in your hands, you'll have all the information that is available on e-lit. So what we hope to do is to broaden it to more access to other aspects of e-lit, including the back end for those officers who are involved in the judicial side. And hopefully also we can see what we can do to facilitate e-hearings through this application. Currently we use Zoom, and I think that may not change very much, but we will have to see how we implement this on our SG Courts app. But one of the other things that we're looking at and we'll be implementing shortly is for asynchronous hearings, which I mentioned generally occur by way of email exchange. This is, of course, cumbersome. People have to keep track of their emails. And basically what we want to do is to ensure that they keep track of the information. So we want to bring this into the app so they don't have to keep track of multiple emails in their inboxes. Now, moving on to some of our near-term projects, we're looking at the use of artificial intelligence in cross-referencing and identification of relevant materials and bundles. You keep hearing me refer to bundles of documents. Those of you who've gone to study in common law jurisdictions, I think will know that in common law countries, we have a lot of documentation thrown up in discovery or disclosure, and it is actually a chore trying to narrow it down. From my own experience as a judge, although the lawyers may get a warehouse full of documents, and sometimes they bring a warehouse full of documents to court, what actually happens in most trials is that basically it can be reduced to a single bundle of documents. That's really important. So what we hope to do with this is essentially over time to develop a system that will enable the judge and the lawyers to see through the documents, identify which are really important, and basically collate it almost in real time. An important area, which is perhaps less apparently technology-centric, is the simplification of our processes and interface with the public. Mr. Tan's office has spent a lot of energy working with consultants to develop what's referred to as a one-stop center. The idea is that we want to use appropriate technology to make human interaction better, and we also want to reduce or eliminate our own processes which make it difficult for people to navigate the court system. So sometimes now when people come in off the street and they have a problem or they want to ask a question, they do get sent from room to room, and it can be almost seem like a never-ending process. So we want to reduce this friction and let them come to a single place where they can have their questions answered, and that's why we want to use technology to enable them to communicate with the right people, for them to get the right information come out, and everything is resolved as far as possible through that one touch with a particular counter, so they don't have to go from place to place. It is actually a bit more difficult to implement in practice than it might sound, because there's been a lot of accumulation of processes which make it a hurdle for the litigant in person or the member of the public, but we are getting there and we hope to implement it fully very shortly. An important area of work is transcription or the recording of information in the courts, and I will touch on that very shortly. So in terms of, I seem to have switched it off. Oh, sorry, I've done it again, all right, sorry. Yes, so in terms of developing our future technology, this basically identifies our general approach, which is common to many jurisdictions, but what I would like to highlight in particular is that we must identify the objectives, the risks, and make a proper assessment of the costs and benefits. And implementing, for example, in particular, the use of AI, we need to be sensitive to data and how it's used, and make sure that we deploy AI in the right environment. One of our concerns has always been that AI is a very sexy term, and everyone wants to label their projects AI, but we need to make sure that we do it properly, and we identify the right areas of interest for AI. So for us, that will be ultimately transcription and translation, where there's a lot of data that will be available. And we also want to explore its use in terms of assisting the judges in making the decisions. The idea is not to replace the judge, but to allow the judge to be able to mine the information in the case and to check on what the lawyers are saying. And importantly, of course, in terms of transcription, what I would like to highlight in terms of our projects in Singapore, it may not be apparent to our friends in Korea, but the situation is a little bit complicated. We speak English, but we speak many kinds of English. There is a Singaporean English, Singaporean accented English. We have people who speak with American accent, people who speak with British accent. We have what we call Singlish, which is a English which has been influenced by Malay and Mandarin and other languages. So it is a mishmash of language, different languages and dialects. We have some mother tongues used in court, Malay, Mandarin, and Tamil. And this presents a challenge. And of course, our population is not very large. We've got 5 million people, and our data set is perhaps not as large as in other countries. So one of our challenges is ensure that we have the appropriate data set for transcription AI. Currently, on one of our projects, we have about 70% accuracy overall. It is still a work in progress, and we hope to get there. Now, in the last few minutes, what I hope to touch on very briefly is to return to one of the themes we noted, which is to ensure that there is access to justice for the pro se litigants or layperson coming into court, and to see how, to give you an insight to our thinking about the use of AI in dispute resolution and case preparation. My gold standard, and I have to emphasize this is a gold standard which may be many, many years, if not decades to come, is to have an ideal system such that when a litigant comes to court, she can just go up to the booth, tell the computer what happened to her, whether she types it out or describes it, and the AI takes what is described and identifies the likely course of action, the evidence that might be required, helps to draft the claim, points out the likelihood of success, and hopefully nudge the litigant to alternative dispute resolution. It is an ideal, it is something I hope to aim for, but I acknowledge, and my team will tell me it is something that maybe the years down the road, but that is something we would aim to do ultimately. What may actually be more achievable would be the use of AI in trying to identify dispute resolution possibility, identifying patterns of facts where certain settlement rates might be more possible or more amenable to the parties, and indicate to parties what the likely settlement outcomes are so that they can be nudged towards ultimate settlement. In court, we hope that eventually we will be able to have an AI system that will identify for the judge to assist the judge in his or her decision, parallel cases based on the facts, the weaknesses in previous cases, points that were highlighted in previous appeals, weaknesses in the present case, such as missing evidence or contradictions in evidence, and what is uncontradicted or solid evidence in that. The decision is always the judge, but the system helps to throw out these data points so the judge is able to consider it in his or her deliberation. And hopefully, at the end of the day, helps to bring everything together so that the judge can write his or her judgments more quickly. But in all of this effort, of course, we need to bear in mind some of the methods that we highlighted earlier, and that in particular includes the challenge of the digital divide. It is perhaps something that is not apparent to many young people, but there are those in society who are not comfortable with technology, even on the smartphone, even to this day. And compounded with that is that there still remain some parts of our population who are not conversant in English and prefer to use their mother tongue. So we need to bear this in mind as we develop our systems. Secondly, importantly, we need to bear in mind the need to prioritize. There are many demands, there are many requests, a lot of sexy things are out there, and we personally may want to pursue them as well, but we have limited resources. I think the challenge now is to recognize that there are many societal demands on public money, and that we need to make sure that whatever we do gives the appropriate return and benefit for the public expenditure that we do incur. So that is something we will bear in mind. The third point for us is to always determine who is the best driver for specific projects. For some of the things we do, we may conclude that the government is the best placed to pursue certain things. For example, for SG Courts app or for transcription and that sort of thing. But sometimes it may be better for us to actually see what is being developed in the market and work towards developing perhaps an off-the-shelf solution if there's something out there, or even to wait for the companies out there to develop something on their own. And we see that in some aspects of our work. Certainly, even for transcription, where companies like Google or IBM may be pursuing their own efforts, and it might be worthwhile for us to actually just take into account what they're doing and see ultimately maybe we should work with them or bring them in or actually put some things up for tender. They might be able to do a better job than the government. So that is something that is always on our minds and that we will need to assess. So ultimately, at this point in Singapore, in the development of technology, we need to bear in mind, as expressed by our Chief Justice Sundaresh Menon, that in an unequal and divided world, we must liberate justice from the convention to courtroom so that we can afford access to those who must require it. So the ideal is for us to be able to take justice away from the court building and enable all users, lawyers, as well as members of the public, sufficient access so that their disputes can be ventilated and resolved according to law. So thank you very much, and I look forward to the discussion. Thank you so much.
Justice Abdullah, thank you very much for the excellent presentation. The presentations should really further our understanding of e-litigation and the use of IT technology in Singapore courts. He also stressed the importance of serving the public interest in every measure we seek. Perhaps we all agree. Please give him another big round of applause. Thank you very much. Now let's move on to the next presentation topic. Let me introduce our second speaker, Judge Ho-Shin Won. Judge Won works at the Daegu High Court. He graduated from Seoul National University School of Law in 1997, was appointed judge of Uijeongbu District Court in 1999. He is a living witness to the introduction of e-litigation to our courts. He oversaw the development of e-litigation system as Director of Judicial IT in the National Court Administration from 2010 to 2013. And he worked to overcome many barriers to the introduction of e-litigation. I wonder if Judge Won ever expected these initiatives to achieve such great success. The topic of his presentation today is Memories of the Court System in Korean Judiciary and some ideas for the next generation e-court system. Please welcome Judge Won with a big round of applause. Let me hand the mic to him. Thank you.
Am I with you? Thank you. Honorable Justice Aedit ABDULLAH of the Supreme Court of Singapore and Honorable Justice No Tae-ah of the Supreme Court of Korea, distinguished speakers, participants, ladies and gentlemen, it gives me great honor and pleasure to be one of the speakers of this timely mannered and meaningful session of the Symposium of the Court Technology and the latest developments. I also convey my sincere gratitude to all the staff of the conference, both here in Korea and Singapore, for preparing this wonderful event. My name is Ho-Shin Won, a judge of Daegu High Court. I joined the judiciary in 2002, and after that, I handled civil, criminal, and administrative cases for more than 15 years. I also served as a director of the Judicial IT Bureau of the National Court Administration of the Supreme Court from 2010 to 2013. Now, let's get started. Yeah. Is it working? Okay, yeah. Now, I would like to draw your attention to these well-suited men and women, the lower left. This is a photo in front of the subordinate courts in Singapore in 2009. Just before implementing the electronic litigation system in Korea, a judge and an IT guy started a journey to Singapore and the United States to find a better way to implement IT systems in the judicial business process. Two well-suited guys bagged meetings, recorded conversations, took screenshots and photos of the IT system in Singapore and the United States. I'm afraid that they looked like spies, but they were desperate, sincere, and straightforward. in getting information for launching the upcoming electronic litigation system in Korea. Thanks to many colleague judges in Singapore and the US, the two men successfully got ideas and useful information to be adapted the new electronic system in Korea. After that, they were happily engaged in the project of launching the e-court, e-litigation system with the goal of supporting all the judicial business of courts by means of high-tech electronic-based technologies. In this occasion, I would like to convey my special thanks to Honorable Magistrate Judge Miranda Yeung of the Subordinate Courts of Singapore and her colleagues Leung Sheng-on, Jayendran Jayapal of the Supreme Court. Like this, I have that kind of double-heading position. My presentation stems from the personal experiences and observations of this double-heading position, both as an inventor and a judge, using the electronic litigation system now. In this presentation, after reviewing some of the features of the litigation, I would like to share some ideas and measures to the next generation. It is not the official idea of the Supreme Court, but I believe it is not against the mainstream of the court. Well, okay. Wow. Let's slide the next page. Yeah. Okay. Okay, got it. I'm sorry. I'm not a tech guy, but let me start it. The history of the judicial informatization of Korea. Because of time restraint, please forgive me to skip the brief of this page, this part, because I believe this is not the venue to deliver the success of our system, but to find the way forward to the upcoming next generation systems. Yeah. This is the portal of our ECF system, the ECF portal site in Korea. And this is the electronic file viewer. Okay. This is the case management system by the court, especially the e-memorandum system. And this is the e-courtroom. Yeah. Okay. Evidently, Korea has achieved a sophisticated level of judicial informatization which has yielded several benefits. Although the implementation of electronic litigation systems resulted in considerable outcomes, the Korean court did face several challenges and complaints regarding the judicial IT system. Some of the technologies are already so widespread in business sector that the system provides nothing new. Most top-class business companies have already adapted this kind of technology. It is not difficult for other countries or judiciaries to observe trendy technology once they have full financial means. This begs many questions to the Korean judiciary. What is the actual effect and novelty of the informatized judicial brings? What are the valuable benefits that informatized legal system provide? Are you satisfied with the fact that we were the front runner of the informatized system in the world? Fundamentally, do you listen to the voices of judges and other personnel who are not familiar with IT skills and who resist from becoming accustomed to the output of the IT guys. Yes and no. Thus, the Supreme Court initiated an effort for re-engineering the current informatized judicial system. The Supreme Court of Korea has begun a new project to rebuild the structure of the judicial IT system, which has been called the next generation of judicial IT systems. To conduct this project, a task force team named Long-Term Project for Judicial Informatization was created. The team reviewed all the current processes of court business and explored up-to-date IT skills from the private sectors. More than 60 judges and court officials participated in the year-long project and proposed diverse views on justice and efficiency via online and offline. After that, the Supreme Court has created a special committee on re-engineering of the judicial informatization systems to review these plans by the task force team. The committee is continued to receive practical review and feedback from the end users of the system, including judges, court clerks, litigants, students, professors, and the public. The Supreme Court of Korea launched a project in 2020 to implement the next generation e-court system, eventually. In this regard, I would like to share several lessons learned and the way forward from my personal experience. It is not certain whether some of the ideas will be implemented to the new system. However, it will be one of the stepping stones to the next generation project for transforming measures to realize sustainable and efficient justice. At the first stage of implementing IT technology, I would like to highlight on the importance of feedbacks from the users. In implementing the e-court system in 2010, I, as an IT director, experienced many trial and errors because I did not get sufficient feedback and communications with the users. More feedbacks guarantee fewer errors to the IT systems. That's the starting point we have to keep in mind when we start next generation project. The system we want to build is something like an organism whose components interact to generate effective functioning. Access to legal information, but both online and offline, can become a strong and transformative enabler to accelerate key advances. Awareness and knowledge about legal information and accessibility can be quite useful to promote legal justice and improvement. Also, by providing free access to legal information, official bodies can strengthen institutional transparency, engage a larger audience of stakeholders, and make many more people aware of both the laws that protect them and the laws that regulate them. Ubiquitous access. Another attribute of information and communications technology that should be highlighted is ubiquitous access. By using a virtual personal network system, VPN, and a virtual machine, we can even access internal court system from around the world as long as the internet is supported. Not all court works are suitable for ubiquitous environment, but this kind of technology will indeed benefit the welfare of court workers and their families. Some futurists predict that technology will replace humans in the future and possibly surpass human intelligence. If this is the case, a time could come where artificial intelligence interfaced with electronic records and electronic litigation system try a case and render judgments instead of human judges. The artificial intelligence device could be used in the real realm as an AI judge or AI law clerk to increase efficiency and to solve complex and difficult legal problems. However, even though AI judge could calculate and consult every single case from the database, the artificial intelligence cannot serve as a substitute for the human mind or feelings of justice. Judicial proceedings are not a matter of probability, but real. It's a human life which should be handled by other humans, considering the very real consequences of legal decisions. On the other hand, there are some concerns regarding the use of this technology in court. I would like to draw your attention to security. When building an IT system in a business process, we have to remember IT inevitably has its loophole in security, as the system is built and administered by human. There's no perfect system nor a 100% secured system. In the future, as the threat of hacking goes up, the level of monitoring should be further fortified as well. As such, to attain a sustainable system, security issues must become a top priority. There are many security hurdles to get well protected, judicial procedure and outputs which diminish court efficiency. But I believe as technology evolves, this kind of leverage will benefit more from less cumbersome security methods. As Judge Abdullah mentioned, digital divide is another problem in this era. At this time, although a treasure trove of information is available to us, access to information is not always guaranteed. There is a gap in those able to access information, which often negatively affects those of lower socioeconomic backgrounds, people with disabilities, or even the elderly. Throughout history, progress towards civilization did not come without its cost. Some are left out and left behind. But it is the judiciary's role and responsibility to embrace those who have been alienated from society. Information technology will become more prevalent by soliciting fancy and efficient methods, including artificial intelligence. For the court and the judicial systems, it will propose useful measures to realize sustainable and efficient justice. As we have seen, technology constitutes an important vehicle for transitioning in this fast-moving IT era. In this sense, the judiciary is not immune from the undergoing revolutionary transformation with the help or threat of IT technology. With today's technology, we anticipate the unchanging values and ideologies of the judicial system to materialize even more. We must focus, however, on the core values and purposes of the judicial service. the justice system is for human. It is above all else for human and justice. Technology is an effective tool to facilitate our advancement, but its use cannot be the final goal we are striving for. I'm convinced that as long as we have a robust mindset toward human and justice, the future is not so dreadful. Efforts to envisage and prepare for the future must continue. I'm sure we can continuously seek future advancements while reminding ourselves that the best way to predict the future is to create it. Lastly, I would like to rephrase and stress an overarching set of ideas to the framework of future next generation system that may include the following. It could be anchored in strong ownership of the court, but could also operate at the regional and national levels. It could reflect the diversity of thoughts, priorities, and policies of all the actors of trials, considering differences in levels and patterns of business process. It could be inclusive and transparent and encourage the participation of various stakeholders, including but not limited to judges, court officials, lawyers, law practitioners, academia, and other stakeholders. It could operate based on sharing information, experiences, and best practices. It could be timely informed to all the level of people to encourage and ensure that no one left behind, and it could include follow-up on progress made by other sectors. It may be too early to raise these suggestions. Some ideas seem to be a little bit idea or unclear. But I believe this presentation can serve as a motivation or a brainstorming exercise to explore methods for attaining sustainable and efficient justice by means of electronic systems. And finally, I hope more symposia and seminars will be held to share ideas and make synergistic efforts to transform our judiciary for a better world with sustainability and efficiency. Thank you for listening.
Judge Wang, thank you very much for your outstanding presentation. He provided us with an expert summary of the past, present, and the future of e-litigation in our courts. Please give him another big round of applause. Thank you so much. Now that the topical presentations are over, we'll move on to the discussion panel. Let me introduce the first panelist, Ken Hwee TAN. He currently acts as the Chief Transformation and Innovation Officer of the Singapore Judiciary. He served as Chief Prosecutor in Financial and Technology Crime Division of the Attorney General's Chambers. He was also Senior Assistant Registrar of the Supreme Court from 2006 to 2010. He holds degrees from both the National University of Singapore Law and the Columbia University. Currently, he spearheads the transformation, digitalization, innovation, and the technology planning of the judiciary. Now, let me bring Chief TI Officer TAN into the conference. Can you hear me well?
Yes.
Are you connected?
Yes.
Yeah.
I believe so. Thank you.
Yeah. Everyone, please welcome Chief TI Officer TAN with a big round of applause. Please take the floor. Thank you.
Thank you, Judge. Good morning, judges, colleagues. Thank you very much for having me on this panel discussion. I have a prepared deck of slides. With your permission, I'd like to go through the slides and then make a few additional comments at the end of that. It is always very fascinating to read about the experiences of other jurisdictions to learn from what are often shared challenges. I'm very much excited to read about the changes and the new projects that you have. And many of your efforts are very much similar and in the same type of challenge that we are facing. We have characterized this as challenges in respect to access to justice, efficiency, and data. And some of the concerns and the questions that our Korean colleagues have asked, we are very fortunate in Singapore that we are smaller and we are able to have the benefit of center of government guidelines and assistance to take care of some of the security issues. And I'll be very happy to share what are some of the mechanisms that we have. And I would like to invite further sharing and exchange of views by both sides after today's symposium. In that line, I'll just mention that we have centrally sourced technology and standards that are used on a whole of government basis. So in terms of what are our VPN requirements, our firewall requirements, our security best practices, a lot of this we have the benefit of having other counterpart agencies within government that would help us set up these rules. So the judiciary is not on its own in coming up with these solutions. We are also very much excited to learn about Korea's attention to free access to legal information, which is very similar to our access to justice efforts as well. One of the challenges that I often get asked is there any resistance in terms of providing legal information? Because some people would say that the courts and the government should not be giving legal advice. How do we make a difference between legal advice and legal information? So related to this, I would like to find out more whether or not there is free and easy access to all records or reports of cases decided by Korean courts. And similar to a concern raised earlier, we are also interested in how do we adequately protect the privacy and the identity of litigants in cases where some of the case details may be embarrassing or may not be appropriate for sharing in a public way. Similarly, we are also very interested in artificial intelligence. We think that it can be very useful, and it already has been very useful for our colleagues in law firms in e-discovery when it comes to having to sift through a large amount of evidence in order to decide what evidence they should put before the court. We also think that AI can help us to predict case outcomes. But very often, one party or the other party will say that their case is special. And there are reasons why their case is an outlier and should not be considered to be the same as 70% of other cases or 80% of other cases that are similar. So that is the challenge, but we think that it should still help us give people a feeling as to, or an idea as to what is the likelihood of success or what is the likely outcome of their case, assuming that what they disclose to the system is accurate. So we are interested to find out how we might integrate the output of an AI system with the real-world needs of judges and litigants in getting answers for their specific situation and circumstances. And how do we address the concern that artificial intelligence may actually hide the programmer's bias, even if it's unconscious bias, so they may not even know that they are treating one category of people differently from another category of people. How do we address the concern that this AI may actually hide this bias and then give people the impression that this is accurate, it is from a computer, it is fair, but actually there may be hidden bias. One of the challenges that we face in doing a lot of the things which Justice Aedit talked about earlier is that we need to have court forms that are easy for litigants in person, the pro se litigant, as well as lawyers. We need to have court forms that are easy for them to fill in. And we are trying to develop methodologies to help us transform traditional court forms. Instead of having it in the traditional manner that our court forms used to be prepared, we want to see how can we devise questionnaires to help citizens in a sequential manner of asking questions, and perhaps even lawyers to help them fill in a form, even if they've never filled in that sort of court form before. So this is something that I would be interested to find out whether there are similar challenges in Korea in terms of dealing with court forms. The digital divide concerns also worry us quite a bit. How do we adequately cater for those who cannot or simply will not learn how to handle technology? In the COVID-19 era, we have had to deal with citizens who could not participate in remote hearings, so we had to devise ways to help them. One of the ways that we tried to help some people was to provide Zoom facilities, where in some courtrooms you can come to court and take part in a remote proceeding because some of the other parties, or maybe even the judge, is actually conducting the proceeding using a remote video attendance. That is my brief slides that I have, but I thought that I should take the limited time that we have to also address some of the issues that have been raised earlier. In terms of our criminal system, it was a multi-stakeholder development. There was a need to consult all the relevant stakeholders before the criminal system was designed and implemented. So this included consultations with the public prosecutor and the Singapore Police Force, because the Singapore Police Force is responsible for doing some of the preparation of the criminal charges. The question was asked whether or not there were conflicts. I would not characterize these issues as being conflicts, but there will be different perspectives. There will be different needs of the different agencies. And whenever we develop technology solutions, we need to try and come to a consensus as to a good balance between the needs of one agency and the needs of another agency. We are interested to find out whether criminal charges can be further digitalized to help us with big data analysis. Our issue was also raised as to what are the insights that we can get from our large body of cases that have been processed through electronic filing. It is true we have a large amount of information, but everybody, as I mentioned earlier, thinks that their case is different. And in order for us to provide that sort of machine learning or big data analysis, we are trying to digitalize our data a lot more. We have digitized it. The difference we make is that when you digitize data, you are essentially taking the paper and you are converting it to, say, for example, a PDF scan of that piece of paper. We want to digitalize. We want to make sure that as much as possible, the data is machine processable. Only if the data is machine processable can we try and get that sort of big data analysis and machine learning that works. Finally, I'll just mention that we are also concerned, as Judge Wan was, that AI should not replace the role of a judge, and that the use of AI can help assist the judge in coming to a decision, but at the end of the day, the judge will still have to make the decision. In terms of cybersecurity, we also agree with Judge that it is not something that we can be absolutely certain will not affect us. We will do our best, but we have the benefit of strong support from center of government agencies that help tell us what are the best practices to put in place for cybersecurity. I've reached the end of my remarks and my contribution for the panel discussion, and I hope to be able to follow up with further discussions by email or further, perhaps smaller group video discussions with colleagues from Korea. Thank you very much.
Chief TI Officer Tan, thank you very much for your in-depth discussion and insightful comments. Thank you so much. After the second panelist discussion, we listen to both speakers' answer or opinion. Let me introduce the second panelist, Judge Soo-Kyun Lee. Judge Lee works at the Seoul High Court. She graduated from Pohang University of Science and Technology in 1991, Korea University School of Law in 1995, and obtained a PhD in Information Management Engineering from Korea University in 2011. She was appointed judge of the Seoul Western District Court in 1997. As the predecessor of Judge Won, she also served as Director of Judicial IT in 2006 and 2007. As both a jurist and an engineer, she has a profound knowledge of e-litigation. When she looks back to the introduction of e-litigation 13 years ago, she seems to have some mixed feelings. Please welcome Judge Lee with a big round of applause. Let me hand the mic to her. Thank you.
Good morning. I am Judge Soo-Kyun Lee of Seoul High Court. It is a great honor for me to join this special seminar. Singapore has always been our best role model in pursuit of e-litigation project. Honorable Justice Aedit ABDULLAH's presentation today made me think that Singapore is still at the forefront of change and innovation. I'd like to thank Justice Abdullah for the valuable presentation and also Mr. Tan for his discussion. In 2006 and 2007, as a Director of Judicial Informatization at the National Court Administration, I had participated in a project to digitize criminal procedures encompassing 4 criminal justice institutions and had reviewed the introduction of e-litigation for civil cases. In 2015, I also took part in a task force team for the long-term project for judicial informatization, as already mentioned by Judge Ho-Shin Won. I'd like to share some more specific thoughts and questions in this discussion. First, I will talk about the principle of public trials in online trials. Judges around the world have begun hearing cases online. This might be one of the major features and the biggest advantages of electronic court. The COVID-19 pandemic is inevitably accelerating this trend. Last year, the Korean judiciary has installed the equipment and software for online trials and revised the civil procedure rule to enable online hearings in a limited occasion. On August 17, the National Assembly passed the bills to amend the Civil and Criminal Procedure Act to enable online trials. The bills will be enacted in November. Our Constitution guarantees the right to public trials. Online trials could potentially be in conflict with the principle of public trial, which has served as a mechanism for a transparent and fair trial. Currently, only the parties involved can access online trials with the access link and password given in advance. This is different from a physical courtroom that is open to anyone, where the public can actually enter. The recent amendment of the Civil Procedure Act regulates that in case of online trials, the court shall take necessary measures for the disclosure of the hearing. What can be measures for the disclosure of the hearing? Broadcasting all online trials are impossible and inappropriate. Recording or making transcript of online trials so that the public can access them and disclosing all trial information and judgment could be a solution. We would be grateful if you could share your wisdom on how Singapore is overcoming these challenges. Next, I'd like to talk about the criminal electronic filing system. In Korea, the electronic litigation has been successfully established due to the relevant legislation and systems. Now the ratio of e-litigation is approximately 90 to 100%. But criminal cases are the only exception. The Korea Integrated Criminal Justice System project had started around 2005, advocating paperless criminal procedures. However, due to conflicts among stakeholders and lack of supporting legislation, the system we built is less than half of the original plan. Recently, the Ministry of Justice has proposed legislation of the Act on the Use of Electronic Documents in Criminal Justice Procedures, and it is expected that the next generation criminal justice information system will be established. According to my research, the ICMS, the Integrated Criminal Case Filing and Management System in Singapore, is a multi-agency, paperless e-filing and e-workflow case management system for criminal cases. The ICMS is used by the courts, the Attorney General's chambers, law firms, the police, and the law enforcement agencies. Since Mr. Tan gave me some answers, so I'll skip several questions, but still, I wonder which institution had led the establishment of the ICMS, and whether each institution's system was built separately and then connected with each other to share information, or whether it was built as an integrated system. And also, I would like to know if the goal was to make the entire criminal procedure paperless, or to share information in the investigation and enforcement stages, and to enable electronic filing only or mainly at the trial stage. In Korea, the BPR ISP for the next generation criminal information system is scheduled to proceed, so the precedent of Singapore would be a good reference. Moving on, I would like to talk about utilization of data. A huge amount of data collected in the e-litigation process could be a good database to draw useful statistics. Statistics such as the average amount of litigation, trial period, and the amount of damages recognized by the court can be extracted from accumulated data and judgments. The average period for each stage of the litigation and the component ratio or tendency of certain kinds of litigation can be used to solve bottlenecks in the litigation process and to reallocate judicial resources appropriately. We can predict the possibility of winning and suggest settlement to the parties involved. In addition, it would be possible to calculate the prevailing rate of a specific law firm or the admitting rate by a specific judge. The courts can utilize various statistics themselves and also provide the public the database itself or a service to extract statistics. Considering the history of e-litigation in Singapore, it seems that a large amount of data have been collected. I wonder how Singapore uses the data to derive meaningful statistics or let private sectors use them. Lastly, I would like to mention AI. Laws, judgments, and legal briefs with logical structures are an ideal subject for analysis and application of AI. With natural language analysis and machine learning, we can derive a valuable judgment algorithm. Justice Abdullah mentioned litigation support for pro se litigants, dispute resolution, and case preparation for judges as the role of the AI system. This appears to be the best case for the application of an early stage AI system. I was impressed by the idea of putting the litigation support for pro se litigants at the top of the list. Using AI to ensure access to justice for information marginalized people would be the best way to narrow the digital divide. Those three systems or functions Justice Abdullah mentioned have different purposes and different user interfaces. For instance, a system supporting computer illiterate people should have intuitively understandable user interface or might need a human assistant. A dispute resolution system should be able to identify cases, draw statistics from relevant precedents, and suggest reasonable settlement proposal. A system for judges should accurately identify and analyze issues and evidence of cases and precedents. Building those systems at the same time might be challenging. It would be of great help if you could tell us who is playing the main role and what plans are being developed to carry out these grand projects. Thank you.
Judge Lee, thank you very much for your in-depth and detailed comments. Thank you so much. Now let's return to the speakers. Let's hear the first speaker's answer or opinion. Justice Aedit ABDULLAH, are you there? Can you hear me?
Yes, thank you. Yes, thank you.
You have the floor.
Thank you so much. To respond quickly to Judge Lee's queries, taking first the availability of the public to view our hearings, we do have a requirement under the law for trials to be open to the public. We have explored in the past the possibility of streaming live, as they do in some jurisdictions. We are not quite ready for that because we have some concerns about some of the things that could happen if we did that. At the moment, though, even in the midst of COVID, what we have arranged for trials that are supposed to be public is that we do have our courtrooms still open to members of the public, and they can come in, and even though the hearing is on Zoom, there will be screens set up so they can follow the proceedings. So basically they come in and they can see all the judges, the parties in that particular case hearing the matter remotely. So basically they use our courtrooms as their own Zoom room. So it's open to the public, they can look at our law list and come in, and that's how the journalists also cover some of our proceedings. So basically at the present moment, for most of our remote hearings are underway for civil matters and for criminal appeals. Criminal trials tend to be held physically for other reasons. Some criminal trials have been held remotely, but because of some issues about the ability of the criminal lawyers to consult their clients immediately, it is generally preferable, or rather most defense lawyers prefer to have criminal trials held physically, so we still hold those in our physical courtrooms with very social distancing measures. I hope that answers the query in relation to public trials. Moving on to the criminal system, the ICMS system that we've developed, it is, as Mr. Tan has mentioned, not an easy process. The courts led the way, but there was active involvement from the police, from the prosecutors, and from the defense bar. The advantage again in Singapore is that we're a small jurisdiction. We all know each other from our normal dealings. There is a national commitment to the adoption of technology, and that has permeated all sectors. And the legal community, the community of lawyers in particular, has gotten used to the idea of rapid change in technology. When we first implemented our EFS system in the 1990s, there was a lot of pain then, a lot of resistance, but because of the experiences from that period, I think these days everyone in the legal community is quite attuned to the need to constantly develop new systems so that we can facilitate the transmission of information. Now, the ICMS system is more than an e-filing system. Information comes in, we deal with the matters on file in the system. Theoretically, it's possible for a large part of it to be paperless, and the results are also recorded within the system and sent out to the parties from the system. The difficulty for us right now, or rather in terms of shortcoming of what we have in place, is that a lot of evidence is still very physical, especially in criminal matters, of course. So I think that's one of the things we have to think about in the future. How do we integrate the adoption of information and that sort of thing, evidence from the hearing process into the system? And the other thing I should note is that in Singapore, as again, common with a lot of common law jurisdictions, a lot of the information is obtained by the prosecutors and the police will not actually be automatically available to the courts. And the police and the Attorney General's chambers, the prosecutors have their own systems in place. And one of the things we have to work at is to how to ensure that the information that is to be shared is transmitted seamlessly from their systems into our system. So that is an ongoing challenge. I can mention that the police were a bit slower in adopting electronic systems for their own investigation purposes. That took a bit of time. There were some challenges there, partly because of personnel. They have a lot of police officers on the ground who had to be geared up for it, and partly also in terms of the reach and scope of the project, which is quite significant for the police force. But they've embarked on it, and I think in future we will see more and more electronic data transmission from their side into the court system. Moving on then to data utilization, we have, as Ken Hwee has mentioned, we have had some experience with that. We're trying to facilitate it even more. One of the things I think we've been short of is in terms of extracting demographic information from the whatever has been filed. For example, in family cases, it will be useful for a family ministry to know the kind of profile of people who file for divorces, the kind of things they ask for, that sort of thing. We've not been able to extract it that readily in the past. We hope to be able to facilitate that and make it easier to collate that kind of information from the things that, from the papers that parties put into court. A lot of information is, of course, also potentially available for us to harvest in terms of court performance, as Judge Lee has indicated, in terms of timeline for hearings, the productivity of the judges, so to speak. Some of that can be extracted readily from our current system. Some of it requires a bit more manpower. It is basically someone looking at the system and trying to do manual calculations. So we're trying to bring out those areas and try to see where we can automate and digitize even more. So it is an ongoing challenge. The ELIT system as we have is a good system, but it is not ideal in some respects, and we are looking at not so much revamping it, but making continuous improvements to it so that it continues to serve our needs for the next few years. Finally, in relation to AI, as I mentioned, it is a target. We hope to get there. We thank Judge Lee for her compliments. We believe it is worthwhile. It is a challenge, and I think we want to have it as a moonshot target. It is always there for us to aspire to, and we hope we'll get there. Perhaps within the next decade, we don't know, perhaps earlier. And as we embark on all our other projects, all our small projects, we will feed our experience from these other initiatives and to see when, and to determine when can we actually embark on these bigger targets and to achieve them. Thank you very much.
Justice Abdullah, thank you very much for your thoughtful and comprehensive answers and opinion. The case of the Singapore court on the issue of public trial in virtual proceedings and how to use artificial intelligence will be a valuable reference for our courts. Thank you so much. Next, let's hear from our second speaker, Judge Wang. You have the floor.
Thank you. Thank you for your interest and understanding to our e-litigation system and meaningful comments. I fully understand that we, Korea and Singapore, have the same problems and several clues for solutions: access to justice, efficiency, and data. In Korea, we have a single centralized judicial system. The electronic litigation system inevitably adopted centrally sourced technology and standards. A huge amount of budget from the government was invested to the system. However, under the principle of separation of powers, the judiciary has its ownership to this e-litigation system. We also have our own standalone data center as well as judicial technicians who operate and monitor the system with our own language and standards. I think that's another phase of independence of judiciary, even in the cybersecurity problems. The second issue, as for the legal information, I can say that we did not encounter resistance in providing legal information because we only offer neutral information through our system. We provide law regulations, judgments, and other useful tips for the judicial procedure, but we do not answer to the specific case for the litigants. Regarding the court records, I would like to say that we have a different rule of the access to the legal information. Korean courts do not provide free access to all courts' records. When I visited several US courts in 2010, I was very surprised that it is deemed a court's rule that all the court records are open to public, even though they have a strict redaction rule for protection of privacy. The situation of Korea is quite different. Court records are not open to public. Court records, including judgments, are only open to the litigants and limited persons who prove the relevance to the case. Even the internal users of the courts, including judges, cannot access specific court records unless they have jurisdiction and right to review the case. AI implementing project is launched after my career of IT director. So I have to confess that I have not so much information of the detail of the AI system. But I'd like to add one problem of this issue. About the programmer's bias, I totally agree with the problem of the programmer's bias, which Chief Officer Tan raised. In the first place, IT directors and IT staffs of the judiciary have to play key roles to supervise this kind of problem. Secondly, the end users of the program, such as judges and lawyers of specific cases, have to verify the output of the AI reasoning and AI judgments. We can also imagine the situation of competition between the AI made by the judiciary and the other AI made by private vendors. To realize this kind of battle between the AIs, more and more court judgments should be open to public. This is my personal opinion. Regarding the court forms, some legal forms are already incorporated to our e-court system. Litigants have to fill out and answer the questions and before submitting the electronic papers to the court. But I have to confess that it is not sufficient that we do not have a lot of set of questionnaires like in Singapore. It is not easy to cover up all the situation and circumstances by the questionnaires because the cases are so diverse and complicated. On the other hand, some judges want more categorized information, but some do not want to get systemized or manipulated information by the questionnaires. I think this is still a dilemma among other problems to be solved by the next generation project. Lastly, I would like to mention the digital divide. I remember litigants in Singapore have to submit all the documents electronically, maybe in civil cases. If they are not familiar with digital devices, they can ask the Service Bureau to help filing. My another recommendation is to make room for paper-based working methods. In Korea, we do not have a mandatory e-filing rule for private litigants, including lawyers, except governments and other public institutes. They have to file a lawsuit and send files via electronic methods. Technically, it is possible to build a system with dual functions for paper and electronic files at the discretion of the user. But there are still people left behind from the paper-based methods, like illiterate, old people, or people with poor eyesight. Like the Service Bureau in Singapore, Helping Hand will be the last resort for the judicial divide. It can be managed by the government or the judiciary or the Lawyers Association. In conclusion, I'm very pleased to realize that we are in the same situation and have same problems, questions, and solutions. I hope the next generation project in Korea and in Singapore to solve these problems with the weapon of equal justice, efficiency, and data. Everything is achievable through technology, but everything is for human. Thank you.
Thank you very much for your excellent answers and opinion, Judge Won. He explained well about artificial intelligence utilization, bridging the digital gaps, and access to records in Korean courts. Thank you so much. It seems that some of you in the audience may have further questions, but due to time constraints, we will be ending the morning session here. Please feel free to continue the discussion over lunch. I hope the coronavirus pandemic is brought under control as soon as possible, and we will be able to hold an in-person meeting in the near future. Thanks again to the speakers, panelists, and to all of you in attendance today. Thank you very much.
네, 특별 세미나 발표 및 토론에 참여해 주신 모든 분들께 다시 한번 큰 박수 부탁드리겠습니다. 이것으로 특별 세미나의 발표와 토론을 모두 마치겠습니다. 지금부터 오찬 시간을 가지겠습니다. 자세한 오찬 안내는 사법정책연구원 담당자들이 해드릴 예정입니다. 식사 이후 오후 1시 30분부터 기조 발표를 시작하겠습니다. 그럼 오후에 뵙겠습니다.